Do you know about the sections that cover the Arbitral Tribunal and the Arbitration Act? Come, let's learn quickly in this video. Section 10 deals with number of arbitrators. The only restriction is that it should not be an even number. The Section 11 deals with appointment of arbitrators. The Section 11 gives power to the court to designate the arbitral institutions for appointing the arbitrators for the disputes. For appointment of arbitrator in a domestic arbitration, you have to go to High Court. For international arbitration, you have to go to the Supreme Court for appointing the arbitrator. 11.1. The nationality of the parties can be any unless otherwise agreed. Procedure for appointment will be decided by the parties. In case of 3 arbitrators, each party will appoint one arbitrator, and the third arbitrator is called the presiding arbitrator, and he will be appointed by the earlierly appointed 2 arbitrators. Arbitral institutions, they will be designated by the court, and there is a procedure for appointment under subsection 4. The procedure given in 11 subsection 4 is: the party will make an application to the court. The court will designate an arbitral institution. Then the arbitral institution will appoint the arbitrator to solve the dispute. When the party can make an application, when the party fails to appoint the arbitrator within 30 days from the request. 2 arbitrators fail to appoint a third arbitrator. That's also within 30 days. In that case, you can make an application to the court. In some cases also, the subsection 4 procedure will apply, where when a procedure agreed by the parties, one party fails to act by the procedure. For appointment of arbitrator, there is a procedure which is given in the arbitration agreement. One party does not follow the procedure, or 2 arbitrators for the parties fail to reach an agreement under the procedure. By following the procedure, they could not appoint an arbitrator. A person fails to perform work entrusted under the procedure. Any person who fails to perform the duties under the procedure also. In this case also, you can follow the subsection 4 procedure and make arbitral institution for appointing the arbitrator. The designation of the arbitral institution for appointing the arbitrator should not be regarded as a delegation of judicial power. The court is not delegating any of its judicial power. You should get a declaration or disclosure from the arbitrator regarding the independence and impartiality, and the qualification also he should make a disclosure. In an international commercial arbitration, the appointment of arbitrator should be of a different nationality than the parties. For example, if one party is Indian and the other party is a US party, the arbitrator should not be either Indian or the United States. He should be of a different nationality. If you make a request to too many arbitral institutions for appointing an arbitrator, the institution to which the first request has been given first is competent to appoint. Only the institution which receives the first request, only that institution can appoint the arbitrator, and an application for appointment which is received by the arbitral institution. The fees for arbitral institution will be decided by the arbitral institution subject to the rates specified in the 4th schedule. This is about the appointment of arbitrator given